Shalom, this is your Ark. Yah is magnified. Coming back with another informative video. I titled this video, The Social Security Administration is Immune from Suit. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, let's get to it. Okay, guys, I'm just making this quick rebuttal video just to clear up the misconception that the Social Security Administration is the non-custodial parent, as a channel like to teach on YouTube who's claiming to have 30 years of experience without any results. Okay, so I'm here to clear up that misconception and give you all better understanding of what's really going on, and to simply show you all that the Social Security Administration is immune from suit. Okay, so for that person to have you all go to court to try to sue the SSA, claiming that the SSA is the non-custodial parent, so the SSA is obligated to pay for child support, you're going to be in for a rude awakening if you go to court with that argument. You're going to automatically lose. Automatic. Okay? I also had an Ark hit me up in my YouTube comments, and he was stating that he went to that person who's producing this nonsense, and that person had got him and his friend a court date in federal court. I'm like, whoop-de-doo. If you have a court date in federal court, guess what's going to happen? The judge is going to give you what? A summary judgment saying that underneath Rule 12b-1 and 12b-6 that you fail to state a claim upon which relief can be granted, and that the Social Security Administration has what? Sovereign immunity. Okay? It's going to be that simple. The only time that I know of that the Social Security Administration waived this sovereignty is for those to file suit against it for the benefits that they believe to be owed to them. Okay? So now, let's say that you was in some type of accident and you can no longer work. So you file your claim with the Social Security Administration, and the SSA says that well, we find as though you are capable of working, and we're going to deny your benefits to receive Social Security insurance, right? So you go to your doctor. Your doctor says, with a doctor note, your doctor send you a letter to the send a note or a letter to the Social Security Administration stating that you are no longer capable of working, and they still deny it. So you say, you know what, I'm gonna hire me an attorney. I'm going to sue the Social Security Administration for I can get the benefits owed to me. That's the only time they waive their sovereign immunity. Okay, such as this case right here, Binder and Binder versus Colvin, right? As you all can see, this court case coming from what? The United States Court of Appeals, Second Circuit, right? Binder and Binder PC plaintiff, appellant, which is a what? A law firm, versus Carolyn W. Colvin, who is the acting commissioner of the Social Security Administration, the defendant appellant. So they sue her and what? And as the agent acting on behalf of the Social Security Administration. But she also has what? Sovereign immunity, because she's acting inside of her scope of duty. Okay? So let's continue. As you can see, this was decided March 21st, 2016. Okay? 3 years ago. You all can, when you get time, type this case law in, read it, get better understanding before you go in these courts finding anything, because you will make a fool out yourself. Let's pick it up at the top line. Well, hold on. This paragraph just basically expresses the judges and all parties involved. So now, let's go to the first paragraph. It states, the Social Security Act provides for successful representatives to be compensated for their services through deduction from payments that their clients are entitled to receive. The instant cases both concern the Social Security Administration alleged failure to disperse attorney fees pursuant to this fee provision, 42 U.S.C. subsection 406A. Then it states plaintiff, appellant, Binder and Binder, a law firm that represents clients before the Social Security Administration, SSA, appeals from summary judgment in two related cases. In both cases, Binder seeks past attorney fees pertaining to its successful representation of claimants who later declared bankruptcy and their debts, including those to Binder, discharged by the bankruptcy courts. When Binder sought to hold the SSA liable for the fees, the district courts below granted summary judgment to the SSA on basis of what? Sovereign immunity. Okay? Case law to back that up. Let's continue. Both courts followed two circuit courts of appeals that have explicitly held that 42 U.S.C. subsection 406A does not constitute a waiver of the SSA's sovereign immunity. So again, the SSA's sovereign immunity. I showed y'all the same thing with the child support agency and the state. I'm showing y'all the same thing pertaining to the SSA. But let's continue. Which, if not waived, precludes such lawsuit. Case law to back it up. Then it says the decision below conflicts with an earlier decision, also from the Eastern District of New York, which found instead that 42 U.S.C. subsection 406A of the Social Security Act does waive sovereign immunity. That's case law to back it up. Then it says, our courts have not previously addressed this issue. We now affirm the conclusion of the two district courts in the instant cases and hold that, regardless of the SSA's statutory duties to withhold attorney fees from payments to successful claimants, there is no waiver of sovereign immunity in 42 U.S.C. subsection 406A that would permit binders lawsuit for money damages. Same thing if you're trying to sue them underneath 1983. Okay, you will get the same results. Why? Because for one, there's no way you can prove that the Social Security Administration is acting outside of its scope of duty that denies you any constitutional rights underneath the color of law. So again, stop listening to these people out here making these false claims, okay? But that's all I'm going to do for today, all right? If anybody who's claiming they have 30 years of experience of dealing with child support, but they have no results showing any evidence of anyone winning, not even of their own, then be worried, man. Be very worried, man. Okay? People have changed their whole pitch. All right? I use my real name. I can use the Social Security number at will if I want to, if I don't. Okay? I didn't change my pitch. I'm the same person. Okay? I don't go by a totally different alias, man. I didn't make up this name to go by because I can no longer use the name that was given to me at birth because the child support agency forced me to change it because I can't beat them in court like other channels do who claim to have 30 years of experience. Again, man, and also, if a channel claiming to have 30 years of experience but their comments are blocked, then what are they trying to hide? Maybe they're trying to hide that they don't have as much experience as they claim to have. That's why they can't show evidence of anything they're saying working or showing any evidence of any proof of anything that they claim to work. Okay? So that's all I'm going to do for today. If anyone need any of my help, hit me up in my email at y'allismagnified@gmail.com. I got more proof coming, more truth coming. I'm going to drop more bombs too, man. This the year of applying pressure. They better get their mind right, man. Get your mind right, because I'm believe me, you think I applied pressure on you the last time I had you running off of YouTube, this cutting off your comments. Wait, I'm on you this time again, and this time I'm gonna have you shut your channel down. So with that being said, you all be blessed. Have a wonderful weekend, guys. Like I said, I might drop more over the weekend. It all depends on how I feel. But yeah, time to apply that pressure. So with that being said, I say shalom, guys. Y'all be blessed.